Pauline. This year's conference celebrates 50 years since the publication of Philip K. Dick's novella, Do Androids Dream of Electric Sheep? This may be more familiar to you as one or perhaps both of two movies, the first by Ridley Scott in 1982 called Blade Runner, and the second called Blade Runner 2049 in 2017. The novel and films depict a dystopian world in which humans have bioengineered synthetic humans, known as replicants, to work on hostile alien worlds. In science fiction, the names given to these creatures are androids or robotic or cyborgs, depending on the nature of the technologies used to create them. Tensions exist in the world between humans and what they have created, that is, replicants. Both movies are therefore about the power to create life and the consequences of using this power irresponsibly. False implanted memory is used as a tool by humans to control these replicants as part of human attempts to colonize other places in the solar system. That's where archivists connect with the science fiction world of possibility of the Blade Runner in the area of memory. We're actually memory professionals. This kind of work in science fiction has early antecedents in the work of Mary Shelley and Frankenstein, and it's an important theme that recurs in science fiction, which to a large extent is about dystopian worlds that might be created if we are not careful. For better or for worse, we are now living in a century where the technological assumptions of Blade Runner will be realised within timeframes that many of you probably will not recognise. The key technologies have already been invented. These are technologies such as artificial intelligence, robotics, bioengineering, and biomechatronics. As we sit here today, corporations such as the Boston Robotics Corporation are creating a generation of android machines which are very, very powerful in terms of what they can do, and in many respects are capable of exhibiting functions that human beings actually perform. Importantly, we do not come from a position of strength in planning for a future in which humans will live harmoniously with the products of their intelligence that they will create, with technologies such as artificial intelligence, robotics, bioengineering, and biomechatronics. If the truth be told, we have not learned to live with each other in circumstances of empathy and respect for human rights, in spite of the efforts of some fierce and untiring advocates working with us today for a better future. We have one of those advocates with us today to give our opening address to this conference. For many of you, Professor Gillian Triggs will need no introduction. Professor Triggs is a former president of the Australian Human Rights Commission between 2012 and 2017 and was Australian Humanist of the Year in 2018. Professor Triggs graduated from Melbourne University in 1968 and gained her PhD in law in 1982. She has worked in international commercial law and was previously a Dean of the Faculty of Law at the University of Sydney. During her tenure at the Australian Human Rights Commission, Professor Triggs spoke out about migration issues, asylum seekers, the incarceration of children in detention centres, same-sex marriage, Aboriginal and Torres Strait Islander incarceration rates, and many other topics in human rights. She is currently chair of Justice Connect, a Victorian-based organisation looking at social justice issues and legal advice. And she has recently acquired an interest and is active in the area of digital rights. I think you will agree that Professor Triggs has demonstrated courage, resolve, and a commendable record in the dedicated pursuit of human rights on our behalf, in spite, at times, of the blowtorch of public criticism from Australian governments and some elements of the community. It is therefore with the greatest pleasure that I welcome Gillian today to give the keynote address at ASA 2018. Gillian has kindly agreed to take questions after her presentation. Delegates, please welcome Professor Gillian Triggs.
Good morning, everybody. It's a huge pleasure for me to be here as part of this extremely interesting conference by archivists looking at the Blade Runner age, identity, memory, evidence, and accountability. A fascinating topic, and one that really has been rather new for me, as I'd not seen the Blade Runner film and couldn't quite see the connection with Archivists. But I've been really pleased to get to know Mark a little more over the last few weeks and months, and he's been of enormous help. But if I've got my facts wrong about the Blade Runner, it's entirely Mark's fault. But to begin, can I thank Dr. Welly for his acknowledgement of welcome to country, in fact, and I too acknowledge the Nonya people and respect their elders, especially any who are with us today. And thank you too to the President, Julia, for her welcome. Well, I have since learned through Mark and through my children what Blade Runner was really all about. And the central idea, so far as I can understand, is that technological advances, artificial intelligence, robotics, bioengineering, can create a dystopian world in which replicants or surrogate humans are given a false implanted memory in order to be controlled by humans. Well, as Mark has quite correctly raised, this question of the impact of technology on our humanism has been raised by many, and particularly authors in literature, many decades ago, about the responsibility we have to use technological powers well. And it was extraordinary. Mark's mentioned Mary Shelley. It is extraordinary that as an 18-year-old in 1818, she understood the arrogance of the scientist Frankenstein, who creates a monster without understanding the social and moral consequences. I think it's rather interesting that one of the reasons she is said to have written this book was because her husband, Percy B. Shelley, that great romantic poet, seemed to have no understanding whatever about the limits of technology and responsibilities to human beings. Well, we also are aware, of course, more recently, that Stephen Hawking has observed that artificial intelligence could in future outperform and replace humans entirely. And perhaps I could give you a personal example of this, because as you may know, one of my roles over the previous 5 years as President of the Human Rights Commission has been to monitor all of the detention centres in Australia over at least 5 years, including juvenile detention centres, but most particularly asylum seeker refugee centres. And about a year ago, 13, 14 months ago, I came to Perth to Yonga Hill. Now, you will all know about Yonga Hill. You'll know where it is and you'll know what it does. But if I ask the question in just about any other part of Australia, have they ever heard of Yonga Hill, and do they have any idea how many people are there and for how long they've been held there, one in an audience of this size may know the answer to those questions. And I wasn't very well informed either until I got to Yonga Hill and saw that hundreds of millions of dollars have been built on a maximum security prison to hold people, men exclusively, certainly when I was there, who are being detained pending deportation for one reason or another. Many of them, of course, asylum seekers and refugees. It's a top state-of-the-art facility. It's a despairing place about 2 hours out of Perth in, I understand, a very important Indigenous area of land. Well, I'd had my 2 or 3 days there talking to detainees, trying to understand their concerns from a perspective of human rights. And one of the things that most concerned those detainees is that, firstly, they've been there without charge or trial for many years. I met one person who'd been in immigration detention for 7 years. But the thing that concerned them particularly was not their conditions, which are actually quite good, given that you're in a maximum security prison, but what concerned them more than anything else was that they were moved around from compound to compound, depending on risk assessment. To what extent were they a risk to the community? Were they to be given greater privileges like attending cooking classes or being allowed to go to the doctor without handcuffs? And I expressed this concern, as usually is my job at the end of a meeting of this kind, in the so-called exit meeting with the superintendent of Yonga Hill. And I should stress that I believe he was one of the better of the superintendents, trained and empathetic, sympathetic and compassionate. That wasn't the issue. The issue was how these people are assessed. That they might, for example, have been in prison in a very low security area they've served out their term for an offence that might add up to 12 months, which means their visas get cancelled, they might find that they're put in maximum security in the so-called detention centre. And they can't understand why this is happening and why these privileges vary so much. So I said, why is it happening? It really causes a lot of distress to the people here, and it might be better if we had a fairer and transparent system. And the answer was, don't worry, because we do this on an algorithm. The determination as to how these people are spending not weeks or months but years of their lives is determined on an algorithm. And I said, how do you know what's feeding the algorithm and what the elements are? Well, that he didn't know because that's sorted out in Canberra. Now, for me, that was really a very good example of the problems of using forms of intelligence, artificial intelligence, algorithms, in order to make decisions that concern human beings. And it's a simple example, and you in your field will know many, many others, but for me it was the most telling one. Not very long after, I gave a radio interview and expressed my concern about the use of the algorithm for these kinds of issues. And I got quite a lot of pushback from people of goodwill and good faith. They said, but isn't it better to have the algorithm make that decision than a subjective view of a superintendent? In the case I'm giving you, a pretty good superintendent, but what if they're a bad one? Isn't it better to have an algorithm? So that put me back a little. I wasn't really sure what the answer to this question is, and maybe it's something you can think about. But it perhaps gives me an opportunity to say, too, that some of the things that I'm talking to you about today have been the subject of fact-checking. So I'm really delighted to be able to come to you this morning and say that the ABC and the RMIT have fact-checked me very recently and said that I was both fair and accurate. So you can take this on trust. Well, the other author that I wanted very briefly to mention, and one that really is very, very powerful, and I urge you to reread him, is the book 1984, of course, by Aldous Huxley, written in about 1947 to 9, as he was dying a very painful death of tuberculosis. But he understood at that time, as almost nobody else seemed to, the risks of false memory and the importance of memory contained in documents, in records, and in data. That is, archives. You might recall that the anti-hero Winston was employed by Big Brother to destroy any archival memory in the newspaper cuttings that might in any way contradict the party's policy or view of the facts. Well, I view the question of recording and archiving memory through the legal prism of human rights. And those rights are to be found, firstly, in the very simple and clear principles of the common law. They're of ancient origin, dating back to at least 800 years of the Magna Carta, but also stated in the many treaties that Australia has accepted and indeed has played a leading role in negotiating throughout the 20th century, beginning, if one can put a line in the historical sand, with that remarkable, feisty, intelligent and brilliant lawyer, Doc Evatt, who fought in the UN for the Charter and fought for the 1948 Universal Declaration of Human Rights. Some of you will be aware that Doc Evatt was president of the General Assembly in 1948 when the Universal Declaration of Human Rights, a very simple document of basic principles, got through the voting system of the General Assembly without a single negative vote. And I understand from the records that that achievement was very much down to Doc Evatt. Can you imagine today Australia being president of the General Assembly, let alone getting a vote without a single negative casted vote? It's quite extraordinary, and it's underpinned the human rights world that Australia has supported and played a very significant role in developing. Well, there are the concern then of this conference is to consider the human rights implications of the failures properly to collect and safeguard records, data, subjective oral history, documents. There are many dangers in the phenomenon of false or lost factual memory. It affects our national well-being, because without those records, our democratic institutions and government officials cannot be held accountable. The checks and the balances don't work. Our history fails to inform the present without proper records. and of particular importance, false memory risks abuses of human rights and a denial of justice. We need to develop laws and ethical protocols to ensure that we use technologies consistently with the rule of law and the social good, however defined. The need to retain and protect information is important for so many reasons. Objective evidence is vital for so many purposes. And as a lawyer, I've known throughout my career that without the evidence, you cannot make your case. And by evidence, I do mean more than just the hard data or statistics. I mean you have to collect the subjective oral history as well. How did people feel about what was going on? What was their perception? This needs to be recorded. And I found in my former position that in making an argument to Parliament or even in the media, you can cite the statistics, but it doesn't move the hearts as well as the minds. You have to tell the story. You have to tell the story, and we often see that story told not always by oral witness, but by the media. And you'll all recall that iconic photograph of a then 16-year-old young Indigenous man in Dondale Detention Centre in a steel restraint with a hood, spit hood over his head. That, on Four Corners, was the pivotal moment, the iconic photograph that meant that the Prime Minister, within hours, was determining on a national, in a Northern Territory Royal Commission. Now, the interesting point is that 2 years earlier, as President of the Commission, I had reported on a number of these cases of the use of steel restraints in the Northern Territory detention centres. And one case documented 16 occasions in which a young Indigenous young boy had been held in those steel restraints with the spit hood, held in isolation for around 12 to 15 hours a day, and when allowed out of his cell, always shackled. All that evidence was given to Parliament and completely ignored. It takes that iconic photograph to shift hearts as well as minds. So by the record, by understanding what is happening in our society, we do need all of these elements of information to be archived and protected. But there are many, many other examples, and one that I think should be mentioned is this problem of statelessness. When I did my law degree in the 60s, I think it was very important to me to read the founding values of the United Nations Charter. And if you go back and read it, it's not a difficult document, you'll see there's a very strong link between breaches of human rights and conflict. And in the case of the Second World War, of course, global conflict, following the war to end all wars, the First World War. But in each case, if you track them through, you will see historically that one of the root causes of conflict and bitter world war has been the failure to abide by fundamental human rights. Not sophisticated ideas that you need a PhD to understand, but fundamental ideas, and one of them being the right of every human being to nationality. And when we see, over the last 18 months or so, what the UN has estimated to be 800,000 people fleeing from Myanmar to one of the poorest countries in the world, Bangladesh, for refuge, one of the reasons is that these Rohingya people have never been granted the simple right of citizenship. They have no papers, there are no documentations, they have no way of operating in the contemporary global environment in which we live. But that statelessness has escalated into high levels of brutality, burning villages, rape, murder, and we've seen the consequences. And indeed, statelessness is one of the very significant issues in our region of the Asia Pacific. It's the biggest cause for the movement of peoples across national boundaries, raising a number of problems. But my key point here is the failure to record and provide identity with documents that respect their who they are as a person and where they are born. And I think the point has been made. Respect is the most important word in human rights law. It's not complicated. It's very, very simple. But we have other areas where the retention and management of evidence is so important. You cannot hold people accountable for crimes against humanity or war crimes in Sri Lanka, for example, where the evidence is so rapidly destroyed. The claims for stolen wages for Indigenous Australians are hard to argue without the evidence. The Institutional Child Sex Abuse Commission relied very, very heavily on whatever evidence it could manage to pull together. When you have the evidence, you can make your case and you can start to use the law. Well, all of those examples are really by way of suggesting that the failure to protect, record, and curate memory accurately, whether as a deliberate strategy of autocratic governments or whether a reflection of benign neglect, pose threats to our democracy, I believe, and to the fundamental common law principles that are so vital to our democracy. But then there's the other side to the coin. That is that the collection and retention of memory through emerging technologies is also a mechanism for surveillance and control of citizens, compounded by the secret sharing of information among international and governmental agencies, particularly Australia in the Five Eyes agreement. The protection and retention of memory poses risks to our freedoms according to universally accepted standards that also need to be managed along with the priority of recording our history and our fundamental facts. The principles that concern me, as I've said, are very straightforward ones. The right to freedom of expression and freedom of thought. The right of access to justice is a very important one. The right to freedom of association, threatened repeatedly across Australia by anti-protest laws in New South Wales, Tasmania, and Queensland. The right to privacy, the right to personal security, the right to non-discrimination, and to equal treatment. But let me give you just one example of this interconnection between the right of access to justice and technology. As Mark has mentioned, I've recently taken over as chair of a group called Justice Connect, which is a New South Wales and Victorian collaboration to put together 10,000 pro bono lawyers to provide legal advice to some of the most vulnerable in our community. And we've done this very recently with a new digital platform. It's very sophisticated, and I'm not going to tangle myself up in knots by trying to tell you how it works. All I can say is that you can do it on your phone, you can get immediate access to Justice Connect, and we then put you in touch with the lawyer with the relevant skills that can help you, whether it's elder abuse that we're seeing so much of at the moment, the detention of children but denied education as is happening, homelessness, of course, domestic violence, all of those issues where vulnerable people have historically and tragically been unable to get proper legal advice. Well, we were somewhat criticised for getting this program going because a lot of people said, well, what's the point of building, and it cost $1 million, what's the point of spending $1 million of money from civil society, from philanthropists, to build this sophisticated digital platform for the most vulnerable in our community who are highly unlikely to be able to access it? In other words, you need them to be able to walk into a storefront. You need them to get that personal touch. And we were a little nervous about whether this was really going to work, but we felt that it was important and we needed to try it. Well, within 24 hours, one of the first people to contact us was a homeless woman over 55. The largest group of homelessness in Australia is women over 55. She'd been living in her car for some weeks, was distraught, had been told about access to Justice Connect, and thankfully had a mobile phone, and she connected. She worked it out very quickly. It's not that difficult. She got the connection, got to Justice Connect, and we got our lawyers working with her to get her somewhere safer and more stable to live. Now, that is, I think, an example of the positive side of the technology as distinct from the rather negative ones. But all of these principles of human rights that are so important are to be determined by a very, very simple standard, articulated by the High Court of Australia, but reflecting international law. And that is the law or the measure, using technology, whatever it happens to be, is it necessary and proportionate to achieve a legitimate objective? That's the principle. And when we look at some of the laws in a moment or two. That is really the principle we need to come back to. Are these laws necessary and proportionate to meet a legitimate expectation or objective? Well, the contemporary challenge of how best to regulate and safeguard memory, which I know is a primary concern today, could be and might usefully be considered in the context of the post-truth environment in which we live. And I'd like to discuss the implications of human rights in this post-truth era, where the truth, the objective truth, will be lost in the fog of social media, spin and doublespeak. If we don't protect facts and truth, what are the implications for the rule of law in our society, and how can human rights be protected? And I'd like to finish by concluding how we might protect human rights in Australia in the future in light of what I see as our isolated and exceptional approach. But let's have a look at some of the examples of the post-truth world we live in. And perhaps the notorious example is by Kellyanne Conway with regard to the allegation on behalf of Mr. Trump, the allegation made by Sean Spicer, the White House press secretary, when he said that the inauguration of Mr. Trump was the largest ever in the entire history of the United States, of the universe, of the entire history of mankind. This statement was factually and objectively untrue. But Kellyanne Conway said to the media, "Well, you're saying it's a falsehood." But the White House press secretary simply gave an alternative fact to that. Now, there's no such thing as an alternative fact. There might be other facts which would sway your mind to a different conclusion, but there's no such thing as an alternative fact. The idea that they're alternative facts and that they too have credibility was, of course, understood in Alice in Wonderland, where Humpty Dumpty said, "When I use a word, it means what I choose it to mean, neither more nor less. The question," said Alice, "is whether you can make words mean so many different things." And as George Orwell said in 1984, when the party oligarch reminded our hero, "Reality exists in the human mind and nowhere else. Whatever the party holds to be truth is truth." And that is why Winston was delegated to destroy those snippets of memory that remained in old newspaper cuttings, to eliminate them so that at no stage could the party's version of truth be challenged. And that is why you're so important and why these issues are increasingly important. But there are many examples of post-truth that have been worrying to me in my former job and continue to worry me. And one that you might remember is the children overboard misstatements, the allegations against Save the Children, that they were encouraging the children on Nauru, and there are 119 of them still there, encouraging them to self-harm. These allegations made by governments over the years, supported by false doctored photographs or taken out of context, these statements are found to be untrue by Senate inquiries some months later. But by then, the political advantage has been achieved. The Howard government won an election within a couple of weeks of the children overboard misstatement. The Senate reported some months later that there was not a scintilla of evidence to support it. But it was at least an element that led to the success of election of a government. So what has become important in this post-truth world is the immediate political gain, not the objective truth. By the time the Senate's reported, everybody's over it, it's boring, it's not really very interesting, and it doesn't attract very much attention. There are others that have had a momentous impact on the world, including the false promises during Brexit that the weekly cost of EU membership would go to the National Health Service. Not only was the figure wrong, but the intent was wrong, and it was admitted even by the Brexiteers later that they would not have won that referendum without that misinformation. A fact check I noticed in relation to President Trump last year was that in 558 days, he made 4,229 false or misleading statements. That is 7.6 such claims a day. His legal advisor, Mayor Juliana, and I've seen this and I've checked it, says in a television interview, the truth isn't truth. And the president has also said, what you just saw, it didn't happen. Well, more chillingly, back at home, I suspect not too many of you were aware of it, but some of you might be. Minister Fifield, Minister for Communications, brought into Parliament a few months ago a new bill. That's called the ABC Fair and Balanced Bill. His argument was, what could possibly go wrong with this? Everybody wants fair and balance. It must pass. Well, mercifully, even the House of Representatives chose not to pass it, and it would never have got through the Senate. And this raises a very interesting paradox for me, and that is this endless repetition of the idea that we have to have things balanced. It's not about balance. Balance gives a false equivalence to something that is actually not true. It's not about 50-50 balances in radio and television interviews and in presentation of arguments. It's about making a measured and fair assessment of the facts that are available to you. And that, of course, is what concerns me about the Fifield bill. Now, we're a long way from 1984, I think, in Australia, but when you see these little things creeping in, you have to be vigilant and you have to be aware that they're being introduced. It's a paradox, then, that while the internet and the social media provide unprecedented access to information, responses to contemporary issues are increasingly emotional, ideological, binary, and subjective. Research, scientific evidence, and data-based reports are often ignored in favour of entrenched personal views. The national debate over climate change and energy policy is, of course, a significant example of that. Well, there's nothing new about the concept of post-truth. It was first used, I understand, as early as the 18th century. But what is particularly worrying is that we have given the spin a credibility that in past generations we've been more sceptical about. Even though we have access to more information today now than we've ever had in our lives, or in the history of mankind, probably, it's become so splintered, so siloed, and so challenging that we've actually walked back into our hall of mirrors to consult only those social media sources that reflect back the views that we already have. There's a narrowing of perspective rather than a broadening of that perspective. And that is what concerns me, that facts do matter and that they should underpin, inform, and guide public policy. Well, my concern then is that a culture in which the truth is manipulated and distorted, buried under a pile of social media and ideological comments, has enabled governments and parliaments to reject the facts, reject evidence-based reports by credible organisations in favour of decision-making that responds to fear, especially terrorism, national security, and the mass movement of peoples seeking our protection. But let us look at one example that had a particular message for me, and this is the Metadata Retention Act of 2015. You'll all be very familiar with that, I'm sure, an obligation to hold metadata for 2 years. You'll recall the debacle at the time that the relevant attorney couldn't describe what metadata is. I'm sure you all knew what metadata is. But the critical point, and the one that I don't think came through well, is that there is access to this very, very broad-ranging data without a warrant. Now, the usual position for hundreds of years in the common law system has been that if agencies that have access to your private and personal material, you must have the supervision of a judge to grant a warrant before that information is made available. It's just a simple, historically based, foundational principle. But as you know, we're left in an odd position today where the government cannot have access to the content of your email, what you're actually saying in it, without a warrant. That's the classical or traditional position. But now the government can have access to all of your metadata, how often you made the phone call and from where and who you associated with, etc., without a warrant at all. In other words, they know much more about you without the warrant than they do if they actually read the content of your email. And there's and this is another little bugbear of mine, there's a very special exception for journalists, because journalists were the ones that stood up against the data retention laws. The squeaky wheel was then given a special exception. So of 25 million Australians, we're all subject to having our metadata accessed without a warrant, whereas journalists, in relation to journalists, that information must be subject to a warrant. So they get an exception, they get a preferred position in society, which I think at least should be debated. So this was an important move, and I'm picking just one of several that I could raise. But it's justified on the grounds of national security, on counter-terrorist needs for greater levels of surveillance and crime control, for forensic evidence, for trials, you have to have evidence, for media and advocacy, and for predictive policing. That all sounds terrific. What it's doing, however, is also invading privacy and creating a chilling effect on our common law freedoms of speech and association. So how do we manage these conflicting ideas? Well, we had a very interesting meeting in Melbourne during the Melbourne Writers' Festival, and I was asked to come along to talk about metadata, which was really a relatively new area for me. And I was asked by the organisers, would I mind them having access to my metadata for 24 hours, because they would just use it as an illustration of how wide metadata information can actually spread. Oh, I said, of course, I'm pure as the driven snow. There is nothing in my metadata that I'm remotely concerned about, and I'm sure a lot of young people think this way as well. So I gave them access to the metadata, the emails and the messages, the messaging, and the things that I'd researched that day for a paper I was doing, and the appointments and so on that I was making for the coming weeks and months, not really giving it very much thought. Well, I went into the Federation Square to be part of this discussion, and I was sitting in the front in one of the way they do these panels these days, in a comfortable seat in the front with a moderator, and they put up on the screen behind me all my metadata, and I could hear the audience tittering, which is the best way of putting it, and I thought, there's nothing funny about my rather ordinary life. What on earth are they on about? And I turned around and looked at the screen, and there, along with all the dates and the research and all, was a lovely little email from me to the Victorian government asking to be granted a seniors card. Well, it made very clear how old I am. But I think it drove the lesson home. I was really astonished that in an apparently benign 24 hours, so much was known about me, even to the point of embarrassing people I was dealing with. I was having lunch with the Chief Justice. I was dealing with all sorts of people in all sorts of contexts. Now, I don't think any harm's come, and that's absolutely fine, but it made the point, and I think more young people in particular need to understand what those risks are. But it does get a lot worse. For the purposes of this discussion and others over the last few weeks, I've been checking fairly regularly how often our national security agencies are looking at the metadata. And when I last looked, 67 government agencies had requested access to metadata of particular people, included ASIO and the securities, but overwhelmingly they were organisations or quangos or government bodies, statutory bodies, of which you've either never heard or not given that much thought to. For example, the Greyhound Racing Association of Victoria wants access to your metadata. The Post Office wants access to your metadata. It's not actually about fighting international crime or terrorism. It's about dealing with tax avoidance, where your money's going, what your connections are, where you might have breached the law in one way or another. Now, you may have different views as to whether that's justified or not, but my point is the governments will say to you, well, just trust us, we need it for security. When the former Prime Minister was asked why we needed the high level of counter-terrorism laws, and in particular the foreign interference laws that I'll mention in a moment, he embarked on no explanation whatsoever. He used two words: dangerous times. Who is going to argue with that? And most troublingly, the opposition is not going to argue with it. So we have a very unusual position in contemporary politics where you have a government and an opposition in lockstep on most of these issues. A little bit of fiddling around the edges, a little bit of amendment to meet particular concerns, but essentially in complete agreement because of this great fear that we have a threat to our national security and the threat of terrorism. And we go back and I ask you to think about it. Are these laws necessary and proportionate to the legitimate objective? And I think reasonable minds will have perhaps different views about this. But it does get a lot worse, because just last week, a whole raft of new legislation has been passed dealing with the new Office of National Intelligence. The Coalition has approved this legislation. It will be introduced into Parliament, I believe, in the next session. It's created a new Tsar of Intelligence with powers to increase the monitoring of citizens and to bypass our privacy laws that are originally designed to block access to personal information. These new powers are unprecedented. They monitor both international and national citizens by scanning social media, and they will include private material such as Facebook on the basis that it's already in the public arena, although it may get behind some of that. The aim is also to share that information, not only amongst the agencies so that they're acting coherently and cohesively together, a good thing, but that information also goes out to the other nations with which we share intelligence across the world. There's been now an exponential growth in surveillance that I think we need at least to question. And the difficulty is that these laws are being passed in Parliament without public scrutiny. And let me give you one example that I thought was particularly opportunistic and cynical. You'll remember that extraordinary day when Parliament passed the marriage equality amendments. And I think we were all relieved that we'd been through a difficult process. It'd been highly political, a lot of misinformation about the so-called lack of religious freedom. Nonsense, by the way. We have Section 116 of the Australian Constitution protects the right to freedom of religion. A lot of misinformation, but nonetheless, an extraordinary day, and political opponents hugging and kissing each other. It was a good warm feeling that day. But what you probably didn't notice is that 2 or 3 hours after that legislation went through, our then Prime Minister came into an almost empty House to propose a new piece of legislation, the Foreign Interference Bill and the Surveillance and Espionage Bill. Now, again, if you ask the man or woman on the street, do we want a piece of legislation that prohibits foreign interference? The answer will almost be certainly, well, of course we do. We don't want attacks on this community. But when you read that legislation, it actually creates registration systems for charities, for civil society. It forms another form of control over information, advocacy, and speaking up. And we don't yet know how it's going to work. But my point is that we are simply unaware in Australia of this vast body of material that's now being passed through Parliament that is creating a surveillance environment. And I think we need much more rigorous checks to understand how this is expanding. Talking of the expansion of technology being a two-edged sword, there are some very interesting things that we might look at to point up the tension between the advances from artificial intelligence and so on and the downside. Some of you, I think, may be flying from Perth to Melbourne this weekend for the AFL Grand Final, but you might note that hundreds of drones have been employed in Melbourne to monitor your activities, along with an estimated 6,000 CCTV cameras. The justification being that the government and police want to detect graffiti artists. But I don't know whether you're particularly talented in that direction, and I certainly don't guarantee that you're going to win either. I'm a Collingwood supporter. But on the other side, drones obviously can be useful, and they can transport, for example, blood to people injured in a conflict. But they can also fire weapons. They can be used to collect evidence and to photograph military atrocities, such as the helicopter machine gunning of civilians on a street in Afghanistan a few years ago. We can use algorithms to screen out mental illness, with a potential also to be discriminatory in breaching the rights of equality of treatment and fair process within our hospitals. 3D technology can create a new arm or a leg, but it can also be used to print a gun. We've seen online technology lead to an exponential increase in sexual abuse, exploitation, and harassment of women. And blockchain technology can be used to increase transparency and reliability of commercial transactions, while also being used by criminal enterprises. Well, the Australian Human Rights Commission has used these technologies and archival facts and records for the work we've been doing over the last 30 years. One of the most important pieces of work we've ever done at the Human Rights Commission was under a former president, Sir Ronald Wilson. You all know Sir Ronald from Perth, a very, very highly regarded, if I may say, black letter conservative lawyer on the High Court of Australia. Under the Constitution, our High Court judges have to step down aged 70, and he did, and he became the president of the Australian Human Rights Commission. And one of the first things he did was to use his presidential powers to call a report into what became known as the Stolen Generation. And he reported, the report was called Bringing Them Home in 1996. And he understood the importance of records to be able to make the judgments as a lawyer that he was able to make in that inquiry. I think it's rather interesting to observe, and it somewhat happened to me as well. Again, as a relatively middle-of-the-road, quite conservative international lawyer that I was, you come into the job, you call an inquiry, you start to see the evidence across the country, and you go from being a quiet, relatively unknown conservative black-letter lawyer to what the government calls a left-wing radical lawyer. Now, something similar happened to Sir Ronald Wilson. And you might recall that when he finished that Bringing Them Home report, the Stolen Generation report, he said, this amounted to genocide. Now, I would never have imagined a High Court judge ever to reach that. It's a very, very hard judgment to make. But that was his conclusion, and he was much criticised for it. And he, I think, probably is one of the most respected and balanced and fair judges that Australia has produced. So I took a little bit of comfort when I suffered a little bit in the public arena myself. But I don't compare myself, of course, with such a great judge. But my point then is that evidence, facts and records are crucial to achieving justice. And that has been true in the report that I called on the unprecedented detention without charge or trial, indefinitely, of asylum seeker children throughout Australia. It was absolutely vital that I had that statistical evidence, and I got it. Much to the government's annoyance, I think, I got it mainly from departmental archives, from the information that was already there on the government record. And one of the things that I think the government had so much trouble dealing with when we talked about the physical and mental condition of these children was that we were using the government's archival material, and we were using evidence from the medical profession gathered at the behest of the Australian government. So that was the miracle for us, that we had incontrovertible evidence as well as the evidence we had used ourselves and researched ourselves. Well, we could go on. I think what I'd like to say particularly is that Australia is in isolation from other parts of the world in dealing with these questions of data protection and gathering. We have some major developments in the international environment, the UN's principles in which a state has a duty to preserve records and history. We have the European Union's general data protection regulations, which require encryption to protect personal data, which require a minimal retention of personal data and mandatory reporting of breaches, and the enforceable right of citizens to inspect personal data and the right to be forgotten in some cases. There are also agreed principles globally for the human rights applications to communications surveillance. My difficulty is that these international trends are going in exactly the opposite direction in Australia. We have an unprecedented number of counter-terrorism laws, more than any other country, described by one scholar as hyper-legislation. We have unprecedented outside wartime of ministerial discretions, which are neither compellable, the minister doesn't have to make the decision, nor are they reviewable by a court of law unless there's been a mistake of law, which usually there hasn't been. We have the creation of a super ministry of home affairs, and we have abuses of office upheld by Senate committees. We have fallen behind international standards with outdated regulations, declining public funding for archives leading to a loss of important memory, while at the same time harvesting data from telecommunications companies in a way that creates a number of breaches. In May this year, the Minister Angus Taylor called for the decryption laws as a top priority, entirely contrary to the European trend to secure individual privacy, and so on. Why is Australia declining? Why are we moving in the opposite direction? There are many reasons, and you can think about them, but one that I think I would like to conclude with is to explain that Australia is isolated from the jurisprudence of human rights protection under our law. We are the only democracy and the only common law country in the world that does not have a federal charter of rights. Now you might say human rights are protected relatively well for most people most of the time in Australia, and that's probably true. But the difficulty is that when you have a vulnerable group or a minority group, they do not have the legal tools to bring to the High Court to insist on their rights being upheld. And that is creating a number of problems across the field of human rights, not only, of course, in the area of data protection, privacy and freedom of expression. But you might say, well, does it really matter if we don't have a charter, even though every other country we want to compare with does? We have a lack. Do we have a constitution that protects us? And the answer again is no, we don't. Our constitution is a practical document for federal-state relations, but it doesn't include many fundamental freedoms. I mentioned earlier we have a right to freedom of religious expression. We have no right to freedom of speech. That is implied by the High Court, implied as a right of political communication. We have no rights to privacy, freedom of association, no prohibition on arbitrary detention without charge or trial, ancient though that principle is in the Magna Carta. Right in the middle of the Magna Carta is that key provision: no man may be detained arbitrarily without charge or trial of his peers. Yet we have rising numbers of people detained on visa cancellations, asylum seekers, some of them just 2 hours drive out from Perth. We have inadequate legislation. The international treaties have never been implemented into Australian domestic law, so the High Court cannot, for example, appeal directly to the Convention on the Rights of the Child. We're a party to it, but we've never given domestic implementation to it by our legislation. And there are many other examples. So what's my solution? Well, there are many solutions. I think we can improve our governance framework. Interesting ideas like proposed by the chief scientist, Alan Finkel, for a Turing stamp. Like a worthy stamp of trust on the way in which technology is used, a little bit like the Heart Foundation's TIC or the current Health Star rating. We could look at the UK's initiative for a Centre for Data Ethics and Innovation. I think that would be a very interesting one. We need to update the Privacy Act, and we need to introduce much better consumer data rights proposed by the Productivity Commission, and I should say are now being supported by the Australian government with $65 million to introduce reforms. But the reform that I would like us to think about more is a proposal for a legislated federal charter of human rights that would include a right to privacy and try to achieve a better proportionality between the high levels of surveillance and private rights, but also to include in it the obligation of governments to support the archiving of information so that the evidence is there to ensure that individuals' rights are maintained. I'm not suggesting a constitutional amendment for a constitutionally entrenched Bill of Rights. Certainly in my lifetime, we are not going to get one. The politics are not there. We can't get rid of the race clause in the Constitution, we can't get recognition of our Indigenous peoples in the Constitution, the chance of getting an entrenched constitutional Bill of Rights are close to zero at the moment. Now, of course, things can change very quickly, but I do believe that if we gave the courts the right to provide a check and a balance against the growing power of Parliament in these areas of surveillance and collection and management of material, I think we would be able to walk or to move into the future with greater levels of comfort for our human rights being respected. So thank you very much for your attention to these issues. I do believe that it's vital for the future that we properly archive the facts and the evidence and that we ensure that those responsible for breaches are held accountable. And good luck for this conference. Thank you very much. Thank you.